Hello. Thank you for your interest in mediation. This video is going to take a few minutes to discuss what mediation is and how it might benefit you. The first question most people usually want answered is, what is mediation? Mediation is an informal meeting where both sides to a dispute sit down with the mediator and try to work out a settlement that is acceptable to both parties. Under Florida law, any dispute that is going to be submitted to the judge for final decision making has to be mediated prior to the judge hearing your case. In a family law case, that includes all family law cases, whether it's a divorce, a paternity case, a child support, increase or decrease case, all those disputes must be mediated prior to the judge hearing the case and rendering a decision on the case. Fortunately, the great many of those kinds of cases settle at mediation, so they don't incur the additional expense of trial preparation and the actual trial itself. The benefit of mediating a case prior to the start of the litigation is simply more cost saving, more time saving. There are, however, a few drawbacks. The drawbacks of having a mediation prior to when the case begins is, first of all, mediation at this stage of the litigation, really before the litigation even begins, is fully voluntary. A mediation after the case has begun will eventually be court-ordered. The judge will require all parties to attend the mediation. However, at this stage, it's purely voluntary. If one party is convinced of the necessity to mediate, the other party is not willing to do so, then you're not going to be able to have a mediation. And you would just unfortunately have to proceed with a litigated divorce. The other drawback is if there isn't full knowledge of all the facts involved in the case by both sides. Typically this occurs when, say, both parties have a 401k in a divorce case, and there needs to be some division of that 401k, but one party isn't fully aware of, say, what the other party's 401k is valued at. That can be still solved prior to a mediation, but without litigation, if the other party simply supplies documentation to prove how much money is in a 401k, whether any money has recently been withdrawn from the 401k. That gives the other person some confidence that they're dealing with the full story. They don't have to rely on the other person's word, which frankly doesn't usually work out very well in a divorce case to begin with. If an agreement is reached through the mediation, you're usually able to get a final judgment entered by the court in relatively short order. In a paternity case, that can be as short as a few days, and in a divorce case, usually much quicker than, well, certainly much quicker than otherwise could get it done, usually anywhere from a few weeks to a month and a half. Next, I'd like to briefly discuss what is the role of the mediator. As a mediator, what do I do at a mediation? First of all, I think it's important to point out that I'm not a judge, I'm not acting as a judge, and I'm not going to decide your case. I'm not going to tell one side that they're right and the other side is wrong. I'm there to listen, and as a family law attorney, there may just be ideas that I can bring to the table to resolve your case that you frankly haven't thought of yet. A mediation at this point will require both sides to give a little and take a little in order that the full case is settled and all the issues are resolved. Most people aren't thrilled after their case has been solved, whether it's at a pre-suit mediation or a mediation prior to trial, but most people aren't really terribly upset either. Like I said, there needs to be some give and take on both sides, some flexibility. If you come into a mediation totally inflexible and say, this is what I want, I'm not going to take anything but that, it's not likely that you're going to settle your case. The other side may be very flexible, but they might not be willing to bend as far as you might like them to. And since, well, let me put it this way, even though I am a lawyer, I'm not either side's lawyer in the mediation. I'm not allowed to give legal advice to either side, and as an ethical matter, I won't be allowed to represent either party in any further litigation if the mediation is not successful. In closing, I think a lot of people ask, well, what's the benefit of mediation? And the short answer is it's cheaper and it's quicker. You're going to end up spending very likely many thousands of dollars on a litigated divorce. Both sides will spend that much money, including the court costs and potential deposition fees, discovery fees, service of process, all those kind of things. It adds up very quickly to a lot of money. Even if most people have that much money and they can spend that much on attorneys, most people would rather spend it on other things. And mediation, really, the cost of mediation really depends on the length of the mediation. Most people think that we can get away with just spending 1 or 2 hours in mediation. That's usually not the way it works. It usually does take a little bit longer. I think a standard mediation usually runs around 3 to 4 hours. It certainly could be shorter, and it could be much longer. Mediation can get spread over a couple of days. Also, in general, mediation that's likely to take 6 or 7 hours is a case with a lot of issues to be discussed and decided. If that were the case, then you're anticipating probably increased litigation costs as well. So the mediation is still probably the better way to go. And lastly, mediation at this point, as I mentioned before, is totally voluntary. So if you do have other questions, please feel free to call me when you can. My number here at the office is in Jacksonville, 904-858-4334. Thank you.